Rapanos v. United States, 547 U.S. 715, was a United States Supreme Court case challenging federal jurisdiction to regulate isolated wetlands under the Clean Water Act. It was the first major environmental case heard by the newly appointed Chief Justice, John Roberts, and Associate Justice, Samuel Alito. The Supreme Court heard the case on February 21, 2006 and issued a decision on June 19, 2006. While 5 justices agreed to void rulings against the plaintiffs, who wanted to fill the wetlands to build a shopping mall and condos, the court was split over further details, with the 4 more conservative justices arguing in favor of a more restrictive reading of the term navigable waters than the 4 more liberal justices. Justice Kennedy did not fully join either position. The case was remanded to the lower court. Ultimately, Rapanos agreed to a nearly $1 million settlement with the EPA while not admitting to any wrongdoing. Background: the case involves developers John A. Rapanos and June Carabel, whose separate projects were stopped because of the environmental regulations that make up the Clean Water Act. In the late 1980s, Rapanos filled 22 acres of wetland that he owned with sand in preparation for the construction of a mall without filing for a permit. He argued that the land was not a wetland and that he was not breaking the law, but his own consultant and state employees disagreed. Rapanos claimed that his land was up to 20 miles from any navigable waterways. However, the term navigable waterway has been broadly interpreted by the U.S. Environmental Protection Agency to include areas connected to a link to waters via tributaries or other similar means. Rapanos was convicted of 2 felonies for filling wetlands in violation of law in 1995. The conviction was overturned and restored several times, but, in the end, he was forced to serve 3 years of probation and pay $5,000 in fines. Eventually, Rapanos appealed the civil case against him, which included millions of dollars of fines, to the Supreme Court of the United States. Carabel, who was involved in the associated case Carabel v. United States Army Corps of Engineers, did seek a permit to build condominiums on 19 acres of wetlands, but the request was denied by the Army Corps of Engineers. Carabel took the issue to the courts, arguing that the federal government did not have jurisdiction. After losing in the Federal District Court and the Sixth Circuit Court of Appeals, Carabel appealed to the United States Supreme Court. In United States v. Riverside Bayview, the unanimous court had found that wetlands abutting Lake St. Clair were included in the court's jurisdiction over waters of the United States. In 2001, a divided court found that the migratory bird rule could not reach isolated ponds in Solid Waste Agency of Northern Cook County v. Army Corps of Engineers. All waters with a significant nexus to navigable waters are covered under the CWA. However, the words significant nexus remains open to judicial interpretation and considerable controversy. Some regulations included water features such as intermittent streams, playa lakes, prairie bottles, sloughs and wetlands as waters of the United States. The case was argued on the same day as S.D. Warren Co. v. Maine Board of Environmental Protection, with the Pacific Legal Foundation arguing for Rapanos and United States Solicitor General Paul Clement arguing for the government. Opinion of the court. The justices were unable to produce an opinion of the court. 4 justices voted to affirm. 4 justices voted to vacate, to strike down the core interpretation of the CWA, and to remand under a new, continuous surface water connection standard. Justice Kennedy also voted to vacate and remand, but under the different, significant nexus standard. All told, the court voted 4-1-4, with 3 justices making oral readings at the opinion announcement, and 5 printed opinions spanning over 100 pages. Both cases were remanded for further proceedings. Justice Scalia's plurality opinion. Justice Antonin Scalia authored a plurality opinion, in which he was joined by Chief Justice John Roberts, Justice Clarence Thomas, and Justice Samuel Alito. Justice Scalia began his analysis by arguing that the court exercises the discretion of an enlightened despot, and quoted factors it used when choosing to exercise jurisdiction, such as aesthetics, and, in general, the needs and welfare of the people. He then criticized the cost associated with exercising jurisdiction, noting that the average applicant spends 788 days and $271,596 on an application, and that, for backfilling his own wet fields, Rapanos faced 63 months in prison. Justice Scalia argued the immense expansion of federal regulation over swampy lands would give the core jurisdiction over half of Alaska and an area the size of California in the lower 48 states. Justice Scalia then detailed the Clean Water Act's history for the litigation, forcing the court to broaden its jurisdiction beyond traditional navigable waters, to its adoption of the migratory bird rule after Riverside Bayview, to SWANCC's rejection of that rule and calls for new regulations. Justice Scalia then noted that the court has still not amended its published regulations, and he emphasized a Government Accountability Office investigation finding disparate standards across different core district offices. Justice Scalia ultimately concluded that waters of the United States should only include relatively permanent, standing or continuously flowing bodies of water because, according to Justice Scalia, that was the definition of the waters in Webster's dictionary. Justice Scalia also rejected Justice Anthony Kennedy's assertion that the same dictionary definition lists floods as an alternative usage because, according to Justice Scalia, it was strange to suppose that Congress had waxed Shakespearean. Therefore, Justice Scalia suggested the core regulations of intermittent streams were useful oxymora. The plurality opinion stated that the Clean Water Act confers federal jurisdiction over non-navigable waters only if the waters exhibit a relatively permanent flow, such as a river, lake, or stream. In addition, a wetland only falls within the court's jurisdiction when there is a continuous surface water connection between it and a relatively permanent water body, such that it is difficult to determine where the water body ends and the wetland begins. In addition to his textualist arguments, Justice Scalia also argued that his conclusions conformed with basic principles of federalism, quoting the CWA's policy to protect the primary responsibilities and rights of the states. Justice Scalia argued the court's inferred jurisdiction failed the clear statement rule. Furthermore, because the court's interpretation stretches the outer limits of Congress's commerce power, Justice Scalia justified his selective interpretation under constitutional avoidance. Justice Scalia spent the rest of his opinion attacking the other justices' arguments. Justice John Paul Stevens wrote that the plurality opinion upset 3 decades of administrative and congressional practice, but Justice Scalia rejected this argument as a curious appeal to entrenched executive error. Justice Scalia also characterized Justice Kennedy's significant nexus test as a gimmick. Justice Kennedy employs to devises his new statute all on his own, and his reasoning. Scalia taunts bullshit turtles all the way down. Chief Justice Roberts' concurring opinion. Chief Justice Roberts wrote separately to note that it was unfortunate the court failed to reach a majority. Additionally, he criticized the court for refusing to publish guidance on the scope of its power even after being warned to do so in SWANCC. Justice Kennedy's concurring opinion. Justice Kennedy wrote an opinion concurring with the judgment of the court. While he agreed that cases should be vacated and remanded, he believed that a wetland, a non-navigable water body, falls within the scope of the Clean Water Act's jurisdiction if it bears a significant nexus to a traditional navigable waterway. Using some of the court's language in SWANCC, Justice Kennedy argued the CWA defines navigable waters as a wetland that possesses a significant nexus to waters that are navigable. In fact, he argued that a nexus exists where the wetland, a water body, either by itself or in combination with other similar sites, significantly affects the physical, biological, and chemical integrity of the downstream navigable waterway. Justice Kennedy spent the rest of his concurring opinion explaining why the 8 other justices were wrong. He characterized Justice Scalia's opinion as inconsistent with the Act's text, structure, and purpose, and noted that what Justice Scalia called wet fields were, in fact, sensitive habitats that provide essential ecosystem services. He also criticized Justice Scalia's selective reliance on only part of the dictionary definition of waters. Justice Kennedy noted that even the Los Angeles River might fail Scalia's TED. Justice Kennedy also attacked, as an empirical matter, Justice Scalia's assertion that silt cannot wash downstream. Likewise, Justice Kennedy criticized Justice Stevens' dissenting opinion, noting, while the plurality reads non-existent requirements into the Act, the dissent reads a central requirement out, referring to the inconsistencies found by the Gao investigation. Justice Kennedy wrote he could not share Justice Stevens' trust in the court's reasonableness. Justice Stevens' dissenting opinion. Justice Stevens wrote a dissenting opinion, in which he was joined by Justice David Souter, Justice Ruth Bader Ginsburg, and Justice Stephen Breyer. Justice Stevens called the court's asserted jurisdiction a quintessential example of the executive's reasonable interpretation, and argued that Riverside Bayview already squarely controls the validity of the regulations. After reviewing in detail the criminal allegations against John Rapanos, Justice Stevens emphasized that the SWANCC court only limited core jurisdiction over truly isolated waters, and that Congress deliberately acquiesced to core regulation when it appropriated funds for the National Wetlands Inventory. Justice Stevens also criticized Justice Scalia's dramatic departure from Riverside Bayview in a creative opinion that is utterly unpersuasive. Justice Stevens derided Justice Scalia's new limit on jurisdiction to relatively permanent bodies of water as an arbitrary distinction. Additionally, Justice Stevens criticized Justice Scalia for citing a dictionary for a proposition it does not contain. Rather, Justice Stevens argued that common sense and common usage treat intermittent streams as streams. Furthermore, Justice Stevens concluded that the very existence of words like alluvium and silt in our language disprove Justice Scalia's assertion that material does not normally wash downstream. Justice Stevens noted that he agreed with Justice Kennedy's description of the cases, and Justice Kennedy's critique of Justice Scalia's plurality opinion. However, Justice Stevens stated he was skeptical that there actually were any adjacent wetlands that would not meet Kennedy's significant nexus test. Nevertheless, Justice Stevens clarified that because all four dissenters adopted the broadest jurisdictional test, they would also find core jurisdiction in any case that meets either Justice Scalia's or Justice Kennedy's test. As such, Justice Stevens assumed Justice Kennedy's approach will be controlling in most cases. Justice Breyers' dissenting opinion. Justice Breyer wrote of separate dissenting to note that he believed the core CWA authority extended to the very limits of the interstate commerce power, because he believed agency expertise would produce better definitions than judicial review. He called on the court to speedily write new regulations. Subsequent developments. Because no single Rapanos opinion garnered a majority of the justices' votes, it is unclear which opinion sets forth the controlling test for wetlands jurisdiction. Chief Justice Roberts observed that the lower courts would likely look to Marks v. United States to guide them in applying the competing Rapanos standards. Marks provides that, when a fragmented court decides a case and no single rationale explaining the result enjoys the assent of 5 justices, the holding of the court may be viewed as that position taken by those members who concurred in the judgments on the narrowest grounds. Quote, Justice Stevens, writing the principal Rapanos dissent, suggested that lower courts could use either the plurality as a Justice Kennedy's test, because both tests would command the support of at least 5 justices. To date, 7 federal appellate courts have been presented with the issue of which Rapanos jurisdictional test is controlling. The Fifth Circuit in United States v. Lucas and the Sixth Circuit in United States v. Cundifer ultimately avoided the question, because those courts determined that the evidence presented was adequate to support federal jurisdiction under either standard. The Seventh Circuit in United States v. Gurk, the Ninth Circuit in Northern California Riverwatch v. City of Healdsburg, and the 11th Circuit in United States v. Robertson held that Justice Kennedy's opinion is controlling. The First Circuit in United States v. Johnson and the 8th Circuit in United States v. Bailey held that jurisdiction may be established under either Rapanos test. One district court has held that the Rapanos plurality opinion is controlling. As Chief Justice Roberts anticipated, the courts adopting the Kennedy standard have done so by invoking Marks. Under Marks, a split decisions binding legal rule is found in the opinion taken by the concurring justices on the narrowest grounds, which has been interpreted as meaning the opinion that is the logical subset of the other opinions in the case. As applied to Rapanos, Marks dictates that if either the plurality of the Kennedy test is a subset of the other, then the test is controlling. The appellate courts that have followed the Kennedy test have concluded that it is a logical subset of the Rapanos plurality test and therefore binding. The appellate courts that have adopted both Rapanos tests, the First and Eighth Circuits, have concluded that the Marks rule does not apply to Rapanos, and that both tests are equally valid. The Supreme Court has denied petitions for writ of certiorari in 6 of the 7 Circuit Court cases addressing the Rapanos split decision. Question. It is therefore unlikely that the Supreme Court will clarify this question in the near future. WOTUS rule. Citing the confusion created by Rapanos, on June 29, 2015 the Corps and EPA promulgated a new 75-page regulation attempting to clarify the scope of waters of the United States, to take effect on August 28. 13 states sued, and on August 27 U. Chief District Judge Ralph R. Erickson issued an injunction blocking the regulation in those states. In separate litigation, on October 9, the divided federal appeals court stayed the rule's application nationwide.